refresh one of those. Well, the last one y'all approved last week, or excuse me, last commissioner meeting, I think, which we won't get to 4 years from now, in 2029. I think was a little over $1 million.
1.1.
Right, right. I knew it was something like that, and I mean, it just strikes me that it's just underlines that, clearly, in general, inflation hasn't gone up 10x since the 80s or the 90s. So it just shows you the sophistication of this equipment now, and I'm sure there are other reasons why the cost is so high, but it's just sobering to see. And I'm sure $97,000 was a lot of money in those days, but
Yes,
it's exponentially more today, but it is what it is.
right, yes,
Thank you.
But I believe technology has changed in that 30 years, and that technology costs a lot of money.
It has,
In
yes.
addition to inflation.
Oh, sure. Yeah.
Other questions or comments? We have a motion, a second on the floor. I'll ask you, call for the question, and ask to vote electronically. The motion is to approve these 3 vehicles that are proposed for surplus. Thank you, by the way. Appreciate it. Voting is complete. Districts 1, 2, 3, and 4 vote aye. Those vehicles are now approved for surplus. Item 14 is submission of names for appointment to the Hospital Authority, post number 5. The Hospital Authority has 1 vacancy. Today we're working on post 5 only. This is an unexpired term ending February 28, 2027, and BOC must submit at least 3 names to the Hospital Authority for consideration, and the Hospital Authority will make their appointments. And the applicants will be on the screen, and as in the past, if there's more than 3 nominated, that's okay. We've done that in the past. The names that are nominated: Philip Etheridge, Rachel Delaney Harvey, Kevin Thompson Hooper, and Bruce Michael Falk. He's better known as Mike Falk. He used to own the pharmacy here in town. So those are the 4 names. Is there a motion?
So moved.
For all 4? Mm-hmm. Okay, we have a motion on the floor to nominate all 4 to the Hospital Authority.
Second.
And we have a second. Motion and a second. Is there discussion? I hear none, so I'll call for the vote. Vote electronically. Voting is complete. Districts 1, 2, 3, and 4 vote aye. We will submit all 4 names to the Hospital Authority for consideration, and they will choose one to fulfill that vacancy. Item number 15, we have 1 person signed in to speak. It's appointment to the Putnam Development Authority. And Barb Vargo, you're signed up to speak on 15.
Okay. We need change. We've got to start now. It's up to you guys to make the appointments. We understand that you believe that people who have been there should stay there, but we need change. When it's about our businesses, when we ask what's going on and we're told that we can't say until it happens, or when we turn around and we get tax abatements that people don't want. We need change, and it needs to be started now. We've started it with the commissioners, and now we got to start it with the boards. I believe that Bill, who's been nominated for this, or has been asked to be put on this, has, told you and made it very clear to you that he does his homework on everything, okay? And he makes sure that he sees both sides of it, whether you like it or not. And I'm telling you now, when you think about this appointment, think about it as the people are asking for change, and we want change now. Thank you.
Thank you. Item number 15, the Putnam Development Authority has 1 member whose term expired 5/1/2025. That was Patty Burns. She has reapplied along with 1 other applicant, and that will be Bill Vargo, and you have those names there on the screen. Did somebody? Okay, I thought somebody to my right had said something. I will call for nominations from any commissioner.
Mr. Chairman, I nominate William Vargo.
Okay, we have William Vargo. Do we have other nominations? Oh, and I'm sorry, I need a second.
Second.
Okay, we have a nomination and a second of Bill Vargo. Any other nominations?
Mr. Chairman, I nominate Patty Burns.
Patty, I will call the roll, unless we'll have discussion first, but if there is any. But then the way this will happen is we'll call the roll, and you just say who you vote for, and we'll vote till we get somebody, till they get 3 votes. Okay, nomination is second on both parties. Is there discussion or comments? Commissioner?
Like to make a general comment. I really appreciate Mr. Vargo applying, and it highlights a more general challenge we have in the county. There's a number of committees that the Board of Commissioners appoint members to, and a number of them have long-standing vacancies. It's very hard to get people to apply. There's a lack of awareness too, so it's a vicious circle. But I really appreciate anyone who is willing to put themselves forward. We need more people to serve on these committees. It's integral to the health of the county and public service. So I'm going to make a point of trying to highlight our committees more generally and try and raise awareness of them. So we have not only 1 or even 2 candidates, but a real array of candidates. And I think that's key to the healthy functioning of these things. Thank you.
And let me point out one thing. Usually it's boards that we're appointing to. This is a board or authority. Authorities are one, I thought it was. I'm not trying to be ugly.
Various kinds of entity that we appoint to.
Other comments? Commissioner Hersey?
Mr. Chairman, you know, the Putnam Development Authority was founded in 1968, as you recall. And at that time, the Constitution of the state of Georgia required that any local appointments be made, or authorities be made as a local constitutional amendment. And now that we've changed the Constitution in 1983 or 84, the Putnam Development Authority was carried forward by our then Representative Jesse Copeland. And is now a local legislative act that supports that PDA. Since the appointment or the creation of that authority, though, the General Assembly has changed the way in which development authorities are created. And while the current authority has a 5-member board, the new legislation would require no fewer than 7 nor more than 9 members on the board, and one of those members may be a county commissioner. It just seems to me that after 50 plus years that maybe it is time to update the Putnam Development Authority and disband the current one and form a new one under the new legislative rules. One of the things that is important to me, I think, is that we do have a county commissioner on the Development Authority, on any authority for that matter, to serve really as a liaison between this board and that authority. I mean, we have one for the Eatonton-Putnam Water and Sewer Authority. Mr. Chairman is on that board and serves as liaison. We have one on the Sinclair Water Authority. Commissioner Wooten serves on that. We don't have a real true liaison between the County Commission and the Hospital Authority or the Putnam Development Authority, and I think
We're on
We
that.
have a list.
I mean, you do,
Go to every meeting.
you go to every meeting, but you're not officially a member of that board.
We can't vote.
Right.
Right. So having an official member of the county commission on these authorities, and I think will serve as a stronger representation and liaison to this committee. Anyway, I just, I'm going down a rabbit hole that I probably shouldn't under these circumstances, so let me stop there and just say that I think it's time to update the Putnam Development Authority.
Other discussions before we call for a vote? Yes, Commissioner Garrett.
Just to say, I echo those comments. I'd be intrigued to learn more, not at this meeting, as to our authority, how it might be done, what might be optimal, get the PDA's point of view. I think it's timely. Thank you.
Okay, anything else? Then I will go ahead and we're going to ask for a vote, and you name the name that you're voting for, either William Vargo or Patricia Burns. Start with one.
Treasurer Burns.
William Vargo.
William Vargo.
We have 2 and 2. I break the tie, and I think both people are well qualified, but I'm going to vote for Patricia Burns. She's been on it, and she's a good person. I do want to get Bill Vargo on a committee or a board soon, and I hope the rest of the commissioners will work with me to do that. So the voting is complete, and there's 3 votes for William Vargo, 2 for Patricia Burns.
Yes. Other way around.
It's 3, I'm sorry, 3 for Patricia Burns, 2 for William Vargo. Patricia Burns is the nominee from here, or the appointment.
Can I ask a question?
Yes.
Is there an opportunity to expand that board? Can we, as a commission, do that?
The way it was set up, and Commissioner Hersey told you that it was set up in 1968, I believe. It is an authority, and it's called a constitutional authority. We can't vary that. If you do, the way I understand you have to do that, and the attorney can correct me, is we would have to totally do away with the existing and then start anew under the new law that was established. Commissioner Hersey, was that 1980 something or 1990
The
something?
new Constitution came in 1983.
83. I knew it was in the 80s, or I thought it was. So that's what it would.
Well, there was a period in which the new Constitution had to be put up as a referendum and then approved by the voters before it became. And the previous local constitutional amendments to be carried forward were, I think, delayed by about a year after the new Constitution. I can't remember. I was not real interested in politics in 1983. I had other
was I?
things on my mind.
I was working hard myself.
Yes.
Same.
Anyway,
Same.
that's kind of where we
I was
are.
going to mention that we, to the chairman's point, we don't do constitutional PDAs anymore. They're through the statute, so you would be limited to the size. You used to be able to have a sort of a one you could change based on the jurisdiction, but unless it was in existence prior to 1983, you wouldn't.
Good enough.
So, and I get to the chairman's point too, it's just beyond our control. The state legislature controls that now, so.
I just think it'd be great if we could expand that a little bit. I think both these individuals would do well. And anyway.
Thank you all for your comments. Bill, thank you for being here. And I'm very serious. We need to move you. And there are some boards, and Lynn can tell you those that are available as they come available. She always keeps a list of them. Okay, moving on to item 16. We have 2 people signed up to speak on item 16 and it is a discussion and possible action regarding conditions applied to rezoning approvals. And Steve Hersey will be speaking to that. But first, we have 2 people signed in. Jerry, is it Jerry Donovan? And Jerry, I apologize. My eyes are still fluttery from going to the eye doctor this morning.
That's all right. Thank you. My name is Jerry Donovan. I own a home and live in Thunder Valley subdivision. At last month's Board of Commissioners meeting, the board voted 3-2 to deny any consideration of prior zoning conditions that were approved by past commission authority. Specifically, the 1995 zoning conditions that prohibited commercial access to Thunder Road and Riverside Drive, which are the two main roads in Thunder Valley. Earlier that same week, the planning and zoning staff approved the preliminary plat of the Thunder Point commercial development that by design will rely on our residential streets for commercial access for some 12 commercial properties. Homeowners of Thunder Valley have officially appealed that planning and zoning action and are waiting that for review. We again ask this commission, as a matter of principle and common sense, to uphold all prior zoning conditions, and in our specific case, to require that Thunder Point gain business access from methods other than the use of Thunder Road and Riverside Drive. Thank you very much for your time and consideration.
Thank you, Jerry. Next signed up is Brandon Burgess.
Good morning.
Morning.
We've been seeing a lot of each other lately. I'm the owner of the same property. I really wasn't aware of what this agenda item was for, since it kind of just a blanket only lists my excerpt from one of our documents, and so that's why I'm here. But to go back, I mean, again, I bought a piece of property that was Zone C1. Those conditions, we've provided the case several times of why they've been dropped. Thank you, commissioners, for honoring that. I went through all the processes, have it all approved, doing what I'm supposed to do, and I just want to still live in District 3. Commissioner Hersey, still, you're my commissioner. You've yet to reach out to me to ask for anything other than completely keep attacking my project. I'm happy to discuss it with you. I pay taxes in this county. I pay taxes in this district. I run a business in this district, and I'm bringing business to this district. So I'm here. I'm here to help. I'm here to develop in this county and do it well. I have a track record of doing it well, and that's what I'll continue to do. I don't know why the continued re-bring up of failed roadblocks. I don't understand the reason why. If it's a personal attack, I have some emails from where we did open records where it says that you're going to try to go against the project, but it's getting very personal now and not so much about the law. So if we can get back to that, that'd be great. Thanks.
Thank you. That's all that's signed up. So now, Commissioner Hersey, you can discuss what you want to discuss. It's your item.
Mr. Chairman, I would like to make a motion to direct the staff to compile a list of all rezoning approvals, including any conditions attached, to attach said list to the official zoning maps, and to complete this task on or before July 1st, 2026.
We have a motion on the floor to direct staff to compile a list of all rezoning approvals, including any conditions attached, to attach said list to the official zoning maps, and to complete this task on or before July 1, 2026. Is there a second to the motion?
Second.
We have a motion and a second. Discussion. Commissioner Hersey?
Mr. Chairman, despite what Mr. Burgess has accused me of, my concern is not just for past rezonings, but also for future rezonings. And the question is whether these conditions that are applied either prior to this or in the future are continue to be valid. And Lynn, if you could, do we have the snippet?
The attachment, I believe, to the commissioners? Is that what you're looking for? This was in the
Go up,
packet, I
go up
believe. is what it
further,
said.
or go down further. All right, right there. So what we are told by our learned attorneys is that the tests to be fulfilled to accomplish adoption of documents by virtue of referring to them as opposed to actually having them within the ordinance itself, that we have to identify them, make a public record of them, make those records accessible to the public, and to give the public notice of their accessibility. I mean, these are 4 conditions. Now, in many discussions that we had last week or the week before, I can't remember, it's been a whirlwind, but we understand that there have been rezonings in the past that have had conditions associated with them. And however, the 1995 issue with Underpoint commercial subdivision turns out is not really relevant to this discussion. What is relevant to this discussion is all of the conditions that have been previously been applied to rezonings. To me, and by this motion, the way to solve this issue and not have to have future commissions deal with it any longer is to go ahead and comply with these 4 points that have been brought up with regard to referring to conditions or rezonings by reference. And the way to do that in sort of simplified terms is to compile a list of all rezonings together with the any conditions that have been attached to them, going back into the early 90s whenever rezoning, or zoning for that matter, occurred in Putnam County. To have that list available together with the current zoning maps and reference to this list so that anybody, member of the public, purchaser of property, whoever, can access them. We will presumably have them digitized and not piles of paper, but and I think that should satisfy any arguments as to whether any conditions applied to rezoning will still be valid. If there is a record that the county commission has rescinded a condition, or that somehow a rezoning has been rescinded, that will also be noted on the zoning maps or the list associated with the zoning maps. And so what I'm asking, and I know it's not an easy job, I'm simply asking the staff to compile that list and to allow for that list to be compiled over the next year. It may be done sooner than that. I don't know. And I would invite the county attorney to opine on whether this is a reasonable request of staff or something that needs to be done for the sake of future commissions as well as the current commission.
County, go ahead, attorney.
I guess my job is to be the reasonable one, right? No, I think
Necessarily.
I think to Commissioner Hersey's point, based on our conversations that we had regarding the specific issue that you dealt with previously and moving forward, I do think this is a step in the process of trying to determine what action you will take regarding your records and some issues that may have come up past zoning actions. I think the reason we have to do this portion of it is because our clerk has told us that we do have an absence of, in our prior documentation, there are blanks regarding zoning conditions being placed on rezoning actions. So we presume that there are going to be issues with those records. So in order to do whatever you may do as a board, this is step one. And by the way, this step would not necessarily mean that you follow through with the other ones, but just from a pure record-keeping standpoint, there is value in having this list together for continuity purposes and to make sure that both members of the public and people who might buy property are aware of previous zoning conditions and what impact those might have. With respect to actions that you'll take to rectify some of those issues, those are down the line, and you as a board may make that choice separate from the choice that you make if you direct this action. As far as the timeline, I'd have to defer to staff regarding that, but zoning started in Putnam County sometime in the 90s, so my assumption is we're not dealing with a ton of records, but obviously
30 years anyway.
Right. So your time frame was a year and a month to come up with those?
Year and 3 weeks.
And I would assume that if it's not enough time, staff can come back and tell you the schedule. But again, you are on step one. There's probably a 4 or 5 step process if we're going where I think Commissioner Hersey wants to get to. Step one is of value to this body, regardless of what step 2, 3, or 4 may be.
Other questions? Commissioner Garrett.
So, Mr. Attorney, a related question. So I know some of the ambiguity over this particular case concerned differences of opinion on whether in 2007 and 2020, if I have the dates right, when the county overhauled, if I can use that word, its zoning ordinances, whether that did or did not mean that historical conditions were or were not valid. So I support Commissioner Hersey's intent here, but is there this bigger issue of whether certain conditions put in at certain points of time are or are not valid now?
I don't think this item would have any impact on that one way or the other, but I do think that if you intend as a body to address that issue, you'll have to have this list together first. And that's the step 2, 3, 4.
Okay, so you're saying, and I understand what you're saying, so let's compile the facts as we understand them, and then knowing that, we'll be in a better position to judge what actually applies now.
Well, not only that, but I think to take actions to address any deficiencies one way or the other.
Right. Thank you.
Other questions? Commissioner Wooten.
Where would who would be responsible? I know our county clerk, we say in the county clerk, but would that be the county clerk, or would it be the planning and zoning that would have to come forward and bring everything up to date? It'd be our county clerk. Okay, I was just wanting to
Be a combination of clerk and zoning.
So all of your zoning conditions will be in your minutes. So the Board of Commissioners takes action to apply the zoning conditions. So this is going to have to go through all the minutes that exist, which all your minutes are on file. The problem is that I think up until 2012, or sometime prior, after that time, we do apparently have an index that shows all the zoning conditions that were established by rezonings, but we know we had zoning prior to that time, and that index is not complete. We would also, though, want to confirm that everything from that we do have on the books is accurate as well. So the intention here would be to look through the minutes. I don't know that the Planning Commission would have any information that the clerk's office doesn't have, but as far as assignment of duties, I'd leave that to the clerk and your county manager.
So what you're saying is we can probably go to 2012, but between 1995 and 2012, it's going to be spotty? Is that?
No, you're going to have to look through all your minutes and determine what outcome came. And I hope that the minutes look as good as they do, but doing this job as long as I've done it, that's not always the case. So, and if there are issues regarding discrepancies or difference of opinion on conditions, those will be brought to the board's attention and we can address those. Again, I hate to be repetitive, but you are in step one. There will be other steps beyond this based on, not really based on information that you get, based on what you want to do with that information.
Other questions? We're still discussing. Yes, Commissioner Garrett, your second time.
Just to clarify, question for Lynn. When we talk about the zoning index, is that a digital document or a physical document? Currently, I mean.
It's an Excel spreadsheet.
Okay, but it's not public facing.
No, I mean anybody could request it
Right.
through open records, but no, it's not
Right.
available.
Okay, thank you.
But Commissioner Garrett's, I'm
just-
sorry, Commissioner, to
just
your
as
point
a-
though, that's the goal. One of the goals, like in step 4 or 5, would be to make that a public-facing document.
Commissioner Hersey, you have the floor.
Yeah, just to kind of do a 1,000-foot view of this. In all of our ordinances concerning zoning, including the 2007 ordinance, under section 66-7, I mean, it clearly states that modifications or repeal of past conditions of approval may be accomplished as provided in the chapter, okay? But nothing in this section shall be construed as repealing or modifying the conditions of operation or condition or use or building permits issued under previous zoning ordinances or resolutions. So what we have done and we continue to do is simply incorporate into our ordinance previous rezoning conditions by reference to them. The argument against this is that we have no systematic record of these, and what this motion would do would be to produce such a systematic record of previous rezoning and rezoning conditions. And we can also make this, accessible to the public. So now, whether we seek to enforce a previous zoning condition or validate it, or this board chooses to rescind a previous condition or a previous rezoning, that, as the county attorney has said, is step number 2. I mean, in order to change a condition that has previously been approved and recorded, we would have to hold a public hearing and then vote to rescind, or we would not have to hold a public hearing to validate and maintain that once we have this list. And I can just say that I know there are conditions associated with rezoning prior to 2007, and I previously cited a parcel that was conditionally rezoned in 2006 for Mr. Art Cook on Wesley Chapel Road. I have no idea if those conditions were ever implemented. I doubt that they were, but are they still valid? I don't know.
So your motion basically is simply to update the records
Update the
and to
records.
make them public.
Yes.
Well, Mr. Chairman, on that point, I'm just looking at the wording of the motion, and to Adam's point that this is a multi-step process. If we include in the motion not only compiling the list but attaching it to the zoning maps, is that a step too far at this stage? Because that might imply that we have decided these conditions are valid when that's another step.
It wouldn't affect the validity one way or the other. It would just be making the public record.
Public
Whether or
record
not
update.
they're enforceable, different question.
Okay, thank you.
But I will tell you that that will be a part of if you wanted to move forward to address that. So,
That'd be phase two, if I
Okay.
understand it right.
And
Commissioner,
that was my
back-
question about the enforcement piece of it. So this is way before that, right?
correct.
Okay.
I don't, if we had in our research regarding the previous item that this commission had gone through, found that that index was accurate, you wouldn't be taking this action.
Okay, thank you.
I believe we've all had our say, and the motion on the floor is to direct the staff to compile a list of all rezoning approvals, including any conditions attached, to attach said list to the official zoning map, and to complete this task on or before July 1st, 2026. It's a year and 3 months. Everybody clear? I'll ask you to vote electronically. Voting is complete. Districts 2, 3, and 1, 2, 3, and 4. I can't count today. Vote aye. The motion is approved, and I will pass this down to our clerk have the appropriate motion. Moving along now to item 17, discussion and possible action regarding reduction in school taxes. Before we get to that, we have a couple of people signed up to speak. First is Jennifer Ray.
Try to say this. Okay, thank you. So I'm here to speak to you today again about, my understanding is Mr. England is trying to change how the assessments of properties have been done to fair market value. 6 times the word assessed appeared on the ballot question. 6 times. Fair market value, not once. So think about that. And I guess he's basing it on the intent of what the school board wanted. Well, I can tell you that I could try calling the Georgia Lottery and tell them I intended to play those numbers that they drew, but I'm pretty sure I'm going to get hung up on, laughed at, and I'm going to be out of luck. So I think today you have the right to make the right decision for the taxpayers of this county, and it is the absolute right thing to do. Because I don't care what the intent is, you have to go by what's in writing, and that's really, I'm sure our attorney can tell you, that's all that really matters. My grandfather passed away in his 40s. I never met him. And she got a widow's pension, and it was less than $800 a month. So there's people, that now should be getting 100% exemption on their school taxes. They're falling into the 50% category because of how Mr. England is doing his taxes. And I'm thinking there's probably a lot of people out there. My grandma did have her house, thank goodness, but it's not right. You have the choice to make the right decision today, and if we'll have to move forward and do what that takes. And I will say that I personally put an open records request in for Mr. England's employment contract because I'd like to see what the consequences are for breaking the law. So thank you.
Thank you. Next let's see, I have to go down the line, and I believe it's Barb Vargo. Barb?
I have to thank the taxpayers watchdog for helping us out with this, but yes, you have to think about the right thing to do. The law is law, and there's no other way to think about it. First of all, I've been told, well, if we do this reduction, we have to raise the mill. If we're going to be doing all this and you're allowing for tax abatement, which I know the Development Authority does it on their own, but you guys have already decided you're going to have the same old, same old. We got to do it the right way, the correct way. I'm not 70 yet, but sooner or later I am going to be. And no, I don't have kids in school. So I think, this is only the right thing to do. The law is the law.
Thank you, Barb. That is all. Now we'll move right along to 17, and Commissioner Hersey, would you like to introduce? It's a discussion and possible action regarding a reduction in school taxes. Commissioner Hersey.
Well, I think to some extent Ms. Ray has encapsulated the issue. The issue is that House Bill 1413 specified that, and which was passed and signed by the governor in 2024, was grants an exemption or a reduction in school board taxes based upon the assessed value of the property. That particular issue was brought to the public in a vote in the November 2024 election, and on a 3-to-1 margin was approved by the voters. Over 9,000 people voted in favor of that reduction in school tax for seniors. It is a homestead exemption, which means that only residents, permanent residents of the county are eligible for it. If you had what is called an F1 exemption already, which is a senior freeze exemption, you were automatically entitled to this exemption as well. It has turned out that the Board of Assessors, Mr. Anglin as the chief tax appraiser, is not using the assessed value, but is using instead the fair market value or appraised value. Now, OCGA 48-5-7A clearly distinguishes between fair market value and assessed value, and provides that the assessed value is 40% of the fair market value. According to the law, according to the will of the voters, the assessed value is supposed to be used to reduce school taxes for senior homesteaders. If the Board of Assessors chooses instead to use the fair market value or appraised value or total value, as they sometimes called, to my way of thinking, they are in fact breaking the law and thwarting the will of the voters. Now, the question is what to do about it. Well, there are some alternatives. One is to have every individual senior who is affected, or anybody else for that matter, can simply file an appeal. Time consuming. Costs the county money to hold a hearing for the appeal before the Board of Equalization. They can only handle so many appeals on any given day, and they are already, I mean, last year they ran well in close to December before they completed all the appeals. They were still working in December, I think, on some of the appeals. And those had nothing to do with the school tax reduction. Now, the Board of Assessors is holding a meeting on Monday at 3 o'clock in the courthouse in our office. And one of the items on the agenda is a discussion of how to handle this HB 1413 school tax reduction. It is hoped by me, and I think several others, that they will change their mind and use the assessed value rather than the fair market value. But apart from that possibility, and to try to save the residents, senior residents, the trouble of having to appeal each individually their valuation and school board taxes, I am proposing a motion. Mr. Chairman,
Yeah, I have
You
your
have a
motion.
copy of the
Yeah, I
motion?
had to pass it down to get it typed in.
no.
If you have another.
No, you have another
I have
copy.
it back.
I have plenty of copies.
Go ahead and make your motion.
So I would move that within 15 days, the county attorney shall file in a court of competent jurisdiction for mandamus in regard to House Bill 1413, unless the Putnam County Board of Assessors agrees to use the assessed value rather than the fair market value as applied to the tax exemption provided in House Bill 1413.
Okay, we have a motion on the floor. Do we have a second?
Second.
We have a motion and a second. Further discussion? I will repeat the motion. The motion is,
Mr. Chairman,
yes,
my hope and expectation was that we were going to hear from Mr. Anglin before we voted.
we can hear from him.
I would like to hear from Mr. Anglin if he's willing.
Chuck, come forward, please. This is, I mean, I don't think the board needs to vote on that. I think everybody nod their heads, say it's okay.
Good afternoon now, right? So, yes, sir.
Well, I emailed you the same basic question, and you said you'll be here,
Right.
you'll explain. So please
Okay.
explain why we're in
Okay.
this situation.
Back when, in December, I noticed that what I discussed with Dr. Weiner, I don't know.
Weiner.
And then the superintendent was Eric Arena. We went through and I showed him what this exemption would be. And the only numbers we ever talked about was fair market value. And so when this came out in the House bill, whatever it was passed, it did say use assessed value. So back in December, I addressed my board about that and said the school board has instructed me to use fair market value, and it says assessed. And this item was on the agenda before Dr. Hersey called and before, I don't know these people, I've never talked to them before. I've talked to Barbara when she worked here, but that was it. But I haven't talked to them about this. This item was already on there for us to discuss using the assessed value instead of fair market value, which they're going to go to probably anyway. I can't guarantee you they'll vote that way because I'm not on the board, but that's what's going to happen. And so it turns out to average about $285,000 to $300,000 more off the school budget. Off their numbers.
More than the 400,000 we've
Yes, sir.
already said.
Yes,
So it's now 800,000,
Yes, sir. Well, 700,000. So,
700,000.
and I gave them that impact. I showed them what it would be, and told them this would probably be what you would be expecting this year.
Okay, other questions?
Just to clarify, you're saying that, I think you said December, that your board voted to
No.
use
No,
fair
they
market
did
value?
No. My board did never vote. I did not vote. I don't have that type of authority to say we're using fair market or assessed. I have to do what my board tells me. They have not voted on this. I was instructed by the school board to use the fair market value, so I was using that. And then we noticed this is not right. So we had it on our agenda to change. And before I received his phone call, before this meeting and everything else.
So you're saying at a forthcoming meeting of your board?
Monday at 3:00, and
Okay.
it's in the tax assessor's office. And we meet once a month, every month, and we talk about, do our values, we approve conservation use, we approve homestead exemption applications. We don't set the terms of what the applications are. That is set by resolution by the commissioners or the school board, and it's passed by legislation. And we just administer the exemptions, that's it.
But you're saying that the tension between what was on the ballot and the way Dr. Rena had instructed you to produce the tax assessments, that tension only has come to light in recent days?
Right. When we finally got the new homestead, we didn't even know about there was a statewide homestead also involved at the same time. So we had to learn how that one was going to work. And then we had to make sure this one was going to work then. And that's when we noticed, hey, this thing said assessed again, and it's just wrong. So that's what we're going to use.
Okay, so just an oversight. I mean, it could have been caught earlier, but it just wasn't for
Right.
whatever reason.
Right. And I had to get clarification on what this was supposed to be from the school board, because they're the ones who pretty much wrote it to begin with. and never discussed assessed value. It was always fair market value, always fair market value. And then here comes that law, and now it's assessed value. So I said, hey, we got to fix this or do something with it.
But when you say here comes this law, the law preceded the ballot.
Right. The law
Right.
came back, whenever it was passed.
Gotta follow the law.
About December or whatever it was, like that. Yeah.
Right.
And so, yeah, my board took an oath to follow the Georgia law. And so that's probably what they would vote on at Monday night or Monday afternoon.
Okay, so you anticipate it being resolved at
Right.
that meeting?
We're not going to send new notices to all the seniors. That would be very expensive. Plus, we have to get this programming change into our system, which takes quite a while. It took 4 months for them to get the new statewide in place. Even though we already had this in place, it was for the new statewide, for other counties to implement it, because they never had this before. They never had what we have.
So citizens will have to appeal?
No, they can appeal if they want to appeal, but the seniors will have, after Monday, they will have this exemption that will be reflected on the upcoming tax bill. And we don't send tax bills, we just send assessment notices.
Right. Okay, thank you.
It seems to me the misunderstanding is between the school board and what the law said.
Yes, sir.
And your board's going to follow the law, if I hear you.
Yes, sir.
Couple of quick questions, Mr. Anglin. First, it is clear to you that there's a difference between assessed value
Oh,
and
yes.
fair market value. I mean,
One's 100%.
There's no,
Right. One's 100%, one's 40%.
no question.
You have an assessed value and a fair market value on your assessment notice.
Yeah. Now, in discussing the school, with the school board, the exemption, did the school board never read the law when they submitted it to the General Assembly for?
I never saw a copy of what was submitted to the General
I mean,
Assembly. I never saw it. I was just on the initial discussions and showed them the numbers, and then I was out of the loop.
Yeah, and so nobody read it, apparently?
I don't know. I'm not privy to that. I don't know.
mean, the school board does have an attorney, don't they?
I imagine so. I don't know. I don't work for them. I don't go to their meetings or anything. So.
These are kind of rhetorical questions. But let me ask you, I don't know what it is this year, but in previous years, can you tell me, for instance, last year, what the total exemptions that Putnam County offered taxpayers?
Okay, right now, if you're over 70, you have
No. Total exemptions.
Total exemptions?
For the L1.
Oh, all of it added together?
All of it added together?
I think it's like close to 600,000 assessed value. I think that's right. Well, the biggest one is conservation.
Last year, our net tax digest was what, $2 billion?
That's about there's 3 billion.
3 billion.
3 billion assessed.
With a B.
Billion with a
Billion.
B.
Assessed
With a
value.
B, yeah. No, fair market, well,
Fair
yeah,
market was
it'd be assessed value.
Fair market was 7 billion.
So the exemptions, as I recall, were in excess of $300 million of assessed value. I mean, the gross tax digest was reduced by about $300 million. So what we're talking about here is a less than $1 million additional exemption for our seniors. Total, but if we use assessed value for this, and the millage involved in that is less than $500,000.
Oh, yes, sir.
I mean, with a $2 billion net tax digest, we would have $2 million per mill.
Right.
I mean,
There's
so a $1 million exemption would be.
There's basically 1,600 taxpayers with a frozen exemption right now.
Yeah.
With the F1 or F5 exemption. F1 is the regular frozen. F5 is the senior veteran 100% disabled. And there's several of those also.
Yeah.
They don't hardly pay any taxes ever.
And so that's what, less than 10% of the total taxpayers, so 9 taxpayers have to pay essentially pay the property this exemption for.
It's about
One
300 out of the
seniors.
1,600. It's about 300 to 400 that will be paying normal taxation like nothing happened to them. But the rest of them, so it's going to go, the way it was, is it said 100,000, 250, and 500,000 were their amounts. When you convert that from assessed to fair market, that's 250,000, and then we'll receive 0 school taxes up if their value is 250 assessed below. 250 to 625 pays 50%, and then 625 to 1.25 million gets a 25% reduction, and then over that amount is taxate.
So basically, everybody who would qualify with a fair market value under 1.25 million, if we use fair market value instead of assessed value, would get a reduced benefit from this law. And let me just say, to me, and we can verify this with our attorney, the school board had every chance of reading this freaking thing, and I don't know if they did not understand the difference between fair market value and assessed value or what, but they can remedy it if they wish by submitting local legislation to change the wording to fair market value. They would have to go through the 2026 General Assembly and a new voter referendum. And I don't know if it was changed to fair market value, if the election would turn out the same as it did.
I don't think so now, no.
So
The law is the law right now.
Can I say one more thing?
Yes, you can.
If you ever have any questions about my office or anything out there, you feel more than free to contact me.
Address us,
Okay, I'm
please.
sorry. I'm just saying, I'm sorry.
Any other questions while we're here? You okay?
Just to clarify,
Nothing? Go ahead.
and this may be a naive question, but as the Board of Commissioners making this motion, it's not that we necessarily have direct jurisdiction, it's just simply us as an official body deciding we want to potentially intervene in a case like this.
I'll let the attorney
Meaning
answer that.
anyone with similar competence could, but it's not that we have direct jurisdiction over how the school board has done this.
That's correct. Go ahead.
I'm very careful, as our previous conversations have been about discussing potential litigation openly, and whether bringing it or defending it. This is a matter from the tax assessor's office. You don't actually employ the tax assessor's office. You appoint members of the Board of Assessors. They have their own employees. Generally speaking, does the Board of Commissioners have the right to seek judicial enforcement for their other boards? Yes. Whether or not this action is necessary is within the discretion of the body. Checking our calendar, your next meeting is June 24th, which would be 17 or 16 days after this meeting. So you already have an established date. So I don't know if you want to take action on this motion or if you want to wait and see what happens for that meeting. If I will check to see what the vote or what the decision is of the tax assessor's office next Monday, and we'll come with a proposed mandamus. Well, come with some paperwork that maybe you guys will do or not do, regardless of the motion. But obviously, I'm trying to be very careful here because it's even more complicated than we're describing it. Because I want to be very clear. Anytime a county is fighting with itself, you have to also provide counsel for the entity you're fighting with. So it is a big taxpayer burden if you want to have litigation among the county. So,
Based on what's been said here, Commissioner Hershey, would you consider delaying this until the next meeting to see what
No.
happens? Okay. We have a motion and a second on the
one-
floor.
One of the reasons is that I really like common law writs. I mean, they Latin names and habeas corpus, mandamus. I mean, you know, it's. Now, the question of having to supply, I mean, the motion says that if in your Monday meeting you go with assessed value, then this motion, you know, no legal action, further legal action is warranted. However, if the Board of Assessors decides that they are going to stick with fair market value, I think this board has no recourse but to seek to have them obey the law, because words do have meaning. Now, whether we have to supply an attorney or pay for an attorney to defend the Board of Tax Assessors, you know, well, we may have to, but let's wait until Monday, but in the meantime, be prepared.
We have a motion and a second on the floor. I believe discussion has been completed. And
Chairman,
we'll,
Mr.
yeah.
Chairman, could I just ask one clarifying question to the attorney? Is another option, rather than us contemplate a lawsuit, to point out the tension to the state and the state then takes action?
I don't think the state of Georgia would have any enforcement in this item. Generally speaking, the way the law works is a taxpayer, the person who pays your taxes, there is a specific process that allows them to seek redress for improperly applied tax assessment or an improperly applied exemption or anything wrong with your taxes. And that it is a process. It's a little simplified. It's not going to court, but it can get there. But the state of Georgia itself probably does not have the ability. And now, I say that there may be some administrative stuff on the Department of Revenue side that may come up later, but from our standpoint, I mentioned this to Commissioner Hersey in my conversations. Taxpayers have more rights than even you do when it comes to paying taxes. They can seek redress for issues they think have either come up in the assessment or how their taxes are actually paid. With respect to the action that may or may not happen, I told Commissioner Hersey this, it's not as clear, but there are examples as I stated earlier, where boards of commissioners have asked for judicial enforcement against boards of assessors.
Okay, thank you.
Can we move forward now and vote? Okay, I'll call for the question, and I'm going to read the motion that's on the floor. And we have a motion and a second. It's been discussed. Within 15 days, the county attorney shall file in a court of competent jurisdiction for mandamus in regards to House Bill 1413, unless the Putnam County Board of Assessors agrees to use the assessed value rather than the fair market value as applied to the tax exemption provided in House Bill 1413. Everybody understand it? We can vote electronically. Voting is complete. Districts 1, 2, 3, and 4 vote aye. The motion carries. And I'll pass that down. We're now to reports. County Manager, do you have a report?
No report today, sir.
County Attorney, do you have a report?
No report, Mr. Chairman.
Commissioner, District 1.
No report, sir.
District 2.
Just quickly, something I forgot to mention earlier about the extended hours for Jimmy Davis Park, just if people are curious. And thank you to the county manager for making this happen, and for Brandon Riley for lobbying for this change. And that's another reason why I thought Brandon would be a great fit for the Jimmy Davis Park Advisory Council. I may not have it exactly right, but previously the park wasn't open in the evenings at all, wasn't open at the weekends at all, and now it is open in the evenings much of the week, and it's open for some hours both on Saturday and Sunday, and I know the community is appreciative of that. And let's hope we can find a way to extend it after the summer. Thank you.
District 3.
just to, if you don't already know, tomorrow is Dairy Festival.
All right.
Typically, it is the hottest day of the year, but this year I think we're actually going to get spared some of the heat. So hopefully everybody will attend.
Commissioner Wooten.
I just want to thank our Public Works. I got a phone call yesterday from a lady, and she was so happy that the trees were out of the road after the storms. And as our county manager says, we've had a lot of them, huge rainfall that washes out culverts and stuff like that. And I just want y'all to really know what these people are doing night and day. And it really doesn't seem like they appreciate it. And another thing I want to say is we need a lot of people on these boards that we need to, and y'all come up and volunteer, please. I mean, it's hard to find people, and that's pretty much all I got to say. Thank y'all.
And I'll tell you, Lynn publishes those boards, and if, I know we need people. We always need people. I have one other thing I need to address. Billy Webster signed up to speak under this section, item 20, is simply for the commissioner's comments. And my final comment is come to the Dairy Festival. The parade will be wonderful. We can't throw candy out anymore, but it'll be a good time. It's supposed to rain tomorrow afternoon late, and we're looking forward to seeing everybody out there. Come and support the dairy industry. Come support our farmers. You know, that's where our food comes from, and we need to really appreciate those guys. Thank you so much. Now I'll call for a motion to adjourn. I'm sorry. I'm sorry. I'll open for adjournment. A motion to adjourn. Is there a second?
Well, sorry, just to clarify, didn't you say that someone had signed up and we'd forgotten them?
But it signed up for number 20, and item number 20 is commissioners' comments, not, and they have to sign up under other things or just general comment.
Oh, you mean that you can't sign up under that? Is what you're saying?
No, not unless you're a commissioner.
Okay, I mean, I don't mind hearing from him if it's relevant, but.
Well, we can see him afterwards. We need to keep it possible. We need to keep it moving. I have a motion. Is there a second to adjourn?
Second.
Motion is second. Is there discussion? Hearing none, vote here. Electronically. Districts 1, 2, 3, and 4 vote aye. This meeting is adjourned. We're going to take a